morning, everyone. Welcome to our session on data ownership, innovation, and privacy, looking for an approach on both sides of the Atlantic. My name is Peggy Valcke. I'm a professor of law at the KU Leuven, the Catholic University of Leuven, and I have the pleasure to moderate this session and also to step in on behalf of the chair, Professor José Luis Piñar, who unfortunately could not make it because his flight was cancelled yesterday. So allow me, please bear with me, to introduce briefly this panel, which is organized by San Pablo University in Madrid, who is an academic partner of CPDP already for the third year in a row. More specifically, at San Pablo University, the panel is organized by the Google Chair on Privacy, Society and Innovation, which is taken up by José Luis Piñar. So I'm very happy to chair and moderate the debate, because it's a very intensive debate for the moment, and it's an ideal debate for an intra- and cross-disciplinary discussion, to which people from different fields of law, ranging from civil law, data protection law, competition law, can contribute, but also people with a non-legal background, economists, engineers, etc. And to some extent, we've tried to reflect that on our panel. What is also important to mention is that the debate is not exclusive for Europe. It's also taking place on the other side of the Atlantic, and we're very happy to also take a closer look at what is happening in Latin America, more specifically in Brazil. Perhaps it's important to note that it's not a new debate. It's actually already 20 years old. If we look at contributions of Pam Samuelson from '99 on privacy as intellectual property, or Paul Schwartz, property, privacy and personal data, we can understand that the debate is almost 20 years old. Thank you for Yann for pointing that out in your very interesting article, recent article. Why is it now that it has been given such prominence lately, with authors like Gian Claudio Malghieri from VUB, Nadia Purtova from Tilburg University, also people in Oxford like Václav Janeček, contributing or increasing the scholarship on this topic? In my view, there are three important reasons for that. First of all, the General Data Protection Regulation is an important cause for the revival of the discussion. We just had a panel before this panel, Do We Still Own Our Data? Which discussed data subject access requests. So to some extent, they also touched on this issue of data ownership. The second reason, in my view, lies with the reform of the consumer protection acquis in the European Union. You may have heard of the proposed Digital Content Directive, where the proposal was to cover also contracts where the consumer doesn't pay in money, but in data. And so that also triggered questions, but hey, wait a minute, if data has a certain value with which you can pay for a service or some content, how does that relate to requirements or data subject rights in the GDPR, where you can withdraw, for instance, your consent? And the third reason, in my view, is that creates actually a tension with the whole debate on data ownership, is this push towards data sharing, openness of data in the interest of innovation and in the interest of making progress in science. So let's all put our data together so we can learn quicker and better from the data that we have. And you may remember that when the Commission proposed its free flow of non-personal data regulation, that IP scholars like Bernd Hugenholz from IVIR in Amsterdam, they thought, what are they doing now? They're suggesting a new sui generis right for non-personal data. Where does that fit in the existing IP toolbox? So those are some of the issues that we will cover in this panel. If we're talking about data ownership, how does that relate to existing notions of property, intangible goods, or intellectual property? who would be the owner of this property? Us, the data subject, the company collecting and processing the data? How do we deal with this tension of data ownership, which means control, but also excluding others from data, with this whole push towards sharing data in the interest of innovation and science? So another question that will come up in the panel, what purpose would it serve to recognize ownership in personal data? Would it serve the interests of protecting privacy and personal data? Would it serve the interest of companies and innovation? So how would it benefit the competing interests at stake? What would be the impacts of formulating such a right of ownership on scientific progress and innovation? So I will stop here and then give the floor to our panelists. The format is traditional in the sense that each panelist will first get 10 to 12 minutes for an introductory statement. And afterwards, the floor will be open to the audience for questions and comments. I will briefly introduce the panelists. I'm starting on my left side. Aure, who is a privacy engineer, Juan Antonio, who is a judge in the Constitutional Court in Spain, Laura Schertel Mendes, I hope I pronounced that correctly, who is a professor at the University in Brazil, and Yann Padova, who is currently a lawyer at Baker & McKenzie, but also has a rich experience as a regulator, having served as Secretary General at the CNIL for about 6 or 8 years.
Was he not?
6. But let's start with Aure, because Aure is actually the non-lawyer on our panel. She has a background in economics and more specifically statistics, and she supports companies with data management and with making connections with other data controllers. So we would be very happy to hear from you, Aure, how your clients, if I may say so, think about this notion of data ownership. Are they in favor? Are they against it? How would they see this? So thank you for illuminating us on that aspect. And normally your slides would come up.
Thank you very much, Peggy, and thank you for joining us on this panel after the one we had this morning, which was more about the fundamental rights and about having access to one's data and how this was going to be used. As Peggy said, I'm not a lawyer, so initial disclaimer, I am a data protection officer for a customer data platform called mParticle out of New York, amongst other things, where I teach as well at Maastricht University. And as Peggy said, as a non-lawyer, I studied econometrics and statistics, and I'm also an entrepreneur. And so I wanted to start off with my vision of what's happening within the data ecosystem and what I'm seeing and why this debate about data ownership needs to take place beyond this general idea of, no, there is no such thing as this notion of ownership and you cannot sell your data. So Peggy asked me to maybe highlight a couple of issues that we see within the data industry. And she touched upon this discussion also about ownership of non-personal data or personal data. What I see currently within the ecosystem I'm active in, and most of my clients, is that certainly we have a problem trying to define what is personal data and what is not. So obviously within the GDPR, you can all say, well, it's defined within Article 4, and we all know what personal data is. But to be honest, it's getting more and more porous, these discussions, certainly when it comes to big data. As we add more information, we get closer to uniquely identifying individuals. I also have a lot of discussion with, for example, Spanish clients who consider that gender is personal data, which often for the more Anglo-Saxons in the room is rather surprising. So this separation, that is one of the first issues that I mainly see, is the separation between personal data and non-personal data is getting increasingly porous. which was also highlighted by, for example, Anne Kavukian, who couldn't believe that Facebook couldn't find personal data within their databases. To be honest, if you look for an email address or you look for an ampersand because a little at is there, it's really easy. But when you're trying to find the rest, it's not that straightforward. So basically what I'm seeing here is that, well, there's the law and there's the legislation and the lawyers and a lot of legal texts, and then there's the engineers. And we don't have the same mental constructions, we don't think the same way, and so there's an interesting article by Elisa Berkman about this clashing of two different types of worlds, and where basically we have to start collaborating together to better understand each other. Something I get a lot is often about the GDPR is to say, hey, I don't understand, it's too vague, it's not clear. A text of law is not a legal requirement, is not a technical requirement. And that's the job that needs to take place today, working together between engineers and legal professions. The second issue that I see is this idea of data flows, traceability, and alignment between contracts, which is basically a work in progress, certainly since the GDPR came into force. Those nice little boxes of data subject, data controller, data processor are very nice legal concepts, but the reality is kind of evolving. We heard this morning also from Max Schrems, he floated this idea that it's possible that the user of Facebook could be a data controller following the rulings of the Court of Justice about joint controllership for Facebook fan pages and comparing this to a WordPress page. So are these little boxes of data subject, data controller, data processor not also slowly but surely becoming porous depending on the type of context? And this is where the GDPR is pushing us from a technical perspective to be more concrete about the data flows. There are a lot of things going on in terms of traceability, understand where the data goes between the different entities, but where we have to work on this alignment with the contracts because, well, the contracts are set up by lawyers, and this is also what a lot of supervisory authorities are saying. It's not just about the contract, it's also actually about your data flows. So these are certain of the works that are being done, and something that always surprises me is that as lawyers we consider purpose to be kind of obvious, but within the real world where I live in, when we pass data from one system to another, purpose isn't always clearly defined. So there's still, I think, a lot of work to be done, which has been pushed forward by the GDPR, but still needs to be done today. And so related to these contract alignments, this is basically what I'm seeing today, almost a year after the enforcement of the GDPR, is to make sure that, well, what you promise within your contracts are actually what you do within your data flows, and also that this is being passed on to the companies that sit behind you one way or another. So alignment between your obligations is something that we need to translate from a technical perspective, and which seems kind of obvious for the legal side, but from the technical side, it doesn't really exist today. So this is what's currently being built. And to paraphrase José Luis Piñar, who couldn't be with us, unfortunately, today, I appreciated reading the only book I read in Spanish about the GDPR, but he really talks about this idea of we shouldn't just manage data, it's about responsible uses of information. And responsible uses of information between what the data subject expects and then what the data controllers promises, but also what all the data processors behind this actually do. And this is, as I said, something that's currently being built. We're all trying to work on this notion of accountability, but it's still work in progress for the moment as each of the actors figure out what their own responsibility is. And the other aspect that I'm actually seeing, so issue number 3, is, well, between the Europeans, who kind of don't really want to talk about ownership, and the other side of the Atlantic, Well, there's a clear discrepancy because there is a marketplace of personal data. The very fact that public instances like the DMV, the ones who do the license plates, are actually part of the data ecosystem. You can buy license plates like you can buy voter registration profiles is reality within the United States, something that for me as a European is unthinkable, but finds itself within the platform. So that really exists, this difference between the United States and Europe. We've been talking about this within the data science industry for a couple of years now. So we understand that data is a new asset class. We understand that it has economic value, but we're kind of stuck in what does that actually mean? So there are very specific things related to data. You can transfer it without decay, but it also creates problems, issues, if we purely talk about this idea of marketplace data ownership. So something I wanted to share here as well as a statistician is something that I worry about a lot, is if I imagine selling my data today, what happens in the long run if that data comes back to haunt me in time t+1? So I have a background, a Jewish history, and there's this story within the Netherlands that they listed religious preferences before World War II, which kind of optimized what came after during World War II by the Germans when they invaded the Netherlands. So this question about I sell my data, yes, today, I maybe get money for it, but what happens further down the road is something that's really difficult to define as well. So there's really this kind of notion of we want to work on this, we want to do something about this. And as an economist, well, I grew up with the invisible hand of Adam Smith. The market will take care of everything, and don't worry, everything's going to be fine. I was reminded in the ethics discussions a couple of months ago by Sarah Spiekerman out of Austria that Adam Smith wrote another book before The Wealth of Nations, which is actually the theory of moral sentiments. And it would be good, I think, for economists also to revisit these former writings by Adam Smith because, well, the marketplace is not going to take care of everything, and it's a collaboration that needs to take place between different actors within the ecosystem. Something I'm seeing also is kind of this discussion about data portability, the potential opportunity of building something else. I appreciate very much the work of Paul-Olivier Dehaye, which is part also of the Digital Clearinghouse of the EDPS. And I get a lot of requests currently about starting to build these kinds of new platforms where data subjects would ask for their data, would push it towards something else, possibly private and public partnerships, things like that. And so I think it's really time to start discussing, well, what does that mean from a legal standpoint? What could be the consequences? Because just saying, no, in Europe we don't want to talk about this is not something that's going to solve for the market economy that's basically moving forward, and certainly a lot of money that's being pushed towards this. So something I learned also during the discussions within the ethics group at the EDPS is instead of moving fast and breaking things, which is more the kind of startup sector way of thinking, we have to make haste slowly, festina lente. So I welcome the debate from legal scholars about, well, the topic of data ownership. Thank you very much.
Thank you very much, Aurélie. Could I just ask you one question? If you talk about data,
yes.
What is it that you have in mind? Is it the data that we transfer, or is it more than that?
Well, it can be data that we transfer, data that we share, data that we create, data that we predict. It's pretty broad, so I leave it to you to further define it.
Okay, thank you very much for clarifying that. We then move on to Mr. Juan Antonio Hernandez. who is, as I said before, judge in the Constitutional Court in Spain, and before that was working as an academic, a professor of civil law. So I understood that you are going to highlight some of the limitations to the concept of data ownership, and especially from the fundamental rights angle. So the floor is yours.
Thank you for the invitation. I'm very happy being here with you all this morning. 12 minutes, it's all time. I have to go straight to the point. I'm going to divide my intervention into 4 parts. The first one is dedicated to clarify the scope of the following remarks. These remarks only have sense regarding this scope and not outside of it. That's why it's so important. In this respect, I have to say that digital economy is focused on data because putting together a big amount of data results in information which is value for businesses. Some studies have already been made on existing rights that provide legal protection for this valuable asset, mainly through contract law, IP rights, and so on. I am not going to talk about that. My point is another one. I'm going to talk about the previous step. At the beginning, there is no information. At the beginning, there is only data itself. I'm going to talk about that, the relations that should be constructed regarding data itself. The second part is that in this new digital economy, which is based on the use of data itself as an important asset, and where this asset is, has a great value, it is not possible not to allocate an economic interest on the data producer. It is not possible not to give the data producer an economic interest. And the data producer, when we are talking about personal data, is the data subject, is the individual. So it is not possible in the end to say that the economic value that has data itself is not referred also to the individual to some extent as a principle, because there are many conditions that I'm going to talk about afterwards. There is a deep discussion on what kind of right is better to protect the allocation of this economic interest to the individual. For me, this discussion is not important today. The main point today is whatever the right would be, there are some questions that raise, and we have to answer them whatever the right would be. If it is property as an exclusive right, or if it is other kind of right. Whatever the right is, we have to answer some questions. And there are 2 questions that would be my third and fourth part of my intervention today. The first question is, what is this economic right for? For what we are going to allocate a right to the individual on the economic value of data? For what? And I have to say that data ownership is useful only for protecting economic value of the data. It is not useful to protect the personality right of the individual. to protect the personality right of the individual, there are another rights. In other words, in Europe, we have developed for 50 years, or more than for 50 years, some principles that we have put together under the reference of data protection, and those principles are the answer to the way to protect the personality right of the individual. What is the conclusion? The conclusion is the data ownership is here not to substitute data protection as a fundamental right. Data protection as a fundamental right will continue to be whatever it will be for protecting personality rights of the individual. And with that conditions, because the end of protection always condition the content of the right. Data ownership is not useful for that. I have to say in this third part, to finish it, that I know, as our moderator has said, and as Yann Padova has written brilliantly in his last essay, in his last article, that there was in the USA in the 90s and even before some academics that wrote about property rule as a way, as a means to protect personality rights. I mean, data protection personality rights. Of course, there was that academic effort, but why? Because they don't have our principles in data protection, and they need to resort to some other way of protecting personality rights in terms of data protection. But we have other principles. We don't need data protection, data ownership to protect personality rights in Europe. We have other ways to do that. And we arrive to the fourth part, which is the limitations, the very intention of my intervention, which is to talk about the limitations of data ownership. The question would be the next one. Is it completely free, the individual, to manage his data ownership, this right allocated to the individuals for the economic side of the data itself? Is it free, the rights holder to manage that data, that right? Is it free? The answer, one answer could be, of course, the owner, it is up to the owner what to do with his or her ownership. This could be an answer to that question. And this answer would be a perfect answer in the 19th century, but we are not living in the 19th century. We are not living in a world as that one in the 19th century. We are not living in a liberalism like that one in the 19th century. We are living in another kind of state. And in the state we are living, it is not possible for any individual to claim that his economic rights are absolute. And this is most true when the object of his right is an important object for society, for some goals that society has to achieve. When the object of a right is an important object for society, the limits of this right are greater. And this is the case. It is not possible for me to make my intervention much longer, but I have to say a couple of words about that. I think, and I'll recommend you to do that, to read a book written in the United States, not in Europe, in the United States, in 2008, and written by Adam Winkler. The title of the book is We the Corporations. If you read that book, you will become aware that many of the rights of the corporations over the history appeared not because of the interest of the corporations, but because the corporations serve the interest of the public. It was an indirect reason of allocating rights to corporations. Why this is important? Because public goals are not only seeked, not only the public power seeks public goals, also the corporation indirectly serves public goals. And the last word for today in this intervention, it has to do with the title of the conference. The title of the conference is Democracy and Data Protection. An important thing for democracy is free elections. And we are very concerned about those events of Cambridge Analytica and how these events have conditioned elections. But there are many other important things in a true democracy. And one of them is that the public power has to select the goals that we have to seek as a society. This is an important point. And this implies also limitations for the rights of individuals. And this is the consequence. I think we have data ownership is a right. Our data continue to be ours. We have a right, an economic right over our data, but it is not an absolute right. It is a regulated right, a right with limits, with many limits, probably one of the more limited right. And truly the last word. Data ownership has more limits than personality rights. The rights that protect the other dimension of the interest of the people in their data. It's important not to mess up the two things. I think that there are strong limitations for data ownership, but I don't think there are strong limitations for the personality right. Thank you.
Thank you very much, Dr. Hernandez. If I may just, thank you also for respecting the time. If I may just ask one tiny question. So if I would bring a case before the Constitutional Court in Spain as a data subject who feels that my rights have been breached, I would better argue it under personality rights than under property rights, which is also a fundamental right, first protocol of the European Convention on Human Rights, because in your view, the first is subject to less restrictions than the latter. Is that correct?
Is that correct? In Spain, there is a different point of view, because for us, property right is not a fundamental right, in the sense that it is not possible to bring a claim to the Constitutional Court on property right. But it is true that it is possible to bring an appeal before the European Court of Human Rights in Strasbourg, but not in Spain. but if it was the case that the two sides could be dealt with in a court, for instance, in the European Court of Human Rights, I think that it depends on the issue. But if you want to have more protection, you should elect the personality right dimension, because the other dimension is it is not strong. It's not
I guess
strong.
that's the dimension that the companies then would try to argue, but we will come to that when I give the floor to Mr. Padova. I would now like to hear from you, Laura, a bit more about what's happening on the other side of the Atlantic. Mrs. Laura Schertel Mendes is, as I said, a professor of civil law at the University of Brasilia. But she's also very familiar with the European context because she holds a PhD from the Humboldt University of Berlin. She also has a strong track record in competition law and consumer protection law, as she has worked at the National Department for Consumer Protection and the Brazilian Competition Authority. And currently, besides her academic activities, she's also private attorney and consultant. The floor is yours.
Thank you very much, Peggy. Good morning, everybody. I thank the organizers, José Luis and Rosario, for the kind invitation to participate in this interesting panel. There are many perspectives, as Peggy noticed in her introduction, to discuss ownership approach. I will catch up on the last topic of Aure's presentation. What if a person sells data or her personal data, or give a lessons to use it, and a harm arises afterwards? I will thus focus this theoretical approach in my presentation. I'll start with some simple questions. Who owns a consumer's credit scoring? The consumer, the credit bureau, or the stores and financial institutions which contributed to feed the score? Who owns a patient's medical record? The patient, the doctor, the hospital, or one could even claim the patient's descendants? Who owns a voter profile? The parties, the voters, or the company which collected and organized the database? Although the questions sound as simple ones, the answers are not simple at all. That is because information is by nature multi-relational, and it cannot be resumed in an ownership model. At this point, it is important to differentiate between the concepts of data and information. As Professor Marian Albers stated, information are elements of meaning that are generated and then used in a particular social context. In order for data to transform into information, it requires an interpretative action that is always linked to the social context in which it is generated. The information content is therefore always context-dependent and can only be understood by its social dimension. In this respect, it would be impossible to guarantee a power to dispose of information. As Gabriele Britz, a judge of the German Constitutional Court, has correctly stated, an information property right would grant the impossible, because the subjective observations and sense constructions of others simply cannot be owned. So, if there is no ownership right on information, one could think on conceiving at least a data ownership right, or a quasi-data ownership right, expression that addresses the idea of data control. But even such a data ownership mechanism would not be able to reduce the risks and consequences of dealing with data and information. Since information is not the sum of the individual data, even a right of data ownership would not do much. The data does not remain unchanged as it was collected from the person. This is mainly due to a certain property of the information. The value of personal data is not in itself, but results from the diverse combination of data and information, which serve as the basis for an interpretation process. In this respect, the consequences and risks from information processing, such as stigmatization or misrepresentation, arise through the interpretative performance of the observer in a particular social context and can therefore be hardly prevented just by distributing ownership rights. If we think about the rationale of data protection law and its main goal, to protect citizens regarding the negative effects of the information processing, it is easy to see that an ownership approach falls short in achieving this purpose. Let's think on the last data scandals, data breaches, election manipulation, algorithm discrimination. Could ownership rights have solved any of these scandals? Furthermore, the ownership model could lead to other difficulties, like the potential to increase data monopolies, hindering competition. It could also be a hindrance to innovation, since facts and data are essential for fostering innovation, and a common consequence of an ownership right is the exclusionary effect, that is, excluding others to collect, treat, and use personal information. Finally, the pure ownership approach could fail to see the situations where there is an legitimate interest from the data controller to process data, though the controller could not be considered the owner of the data. I will draw now a comparison to the state of the art of this discussion in Brazil. Data protection in Brazil has recently undergone a very significant change with the approval of the Brazilian General Data Protection Act. Even before that, however, the country already counted with a data protection framework, which comprises privacy rights provided in the Brazilian Constitution and several statutes dealing directly with personal data, such as the Consumer Protection Code, the Credit Reporting Act, and the Marco Civil da Internet, the Brazilian Internet Rights Framework. The Brazilian Constitution directly addresses matters regarding information by providing for the fundamental rights of freedom of expression and access to information and transparency. It also acknowledges the inviolability of private life and privacy of telephonic, telegraphic, and data communications. Furthermore, it provides for the writ of habeas data, which aims to provide citizens with a way to access and correct data about themselves, held by public entities and third parties. In 2018, Brazil approved its first General Data Protection Act, in which formulation I had the honor to participate with Danilo Doneda. After a very long period of legislative debate, several different bills, and numerous difficulties. Some articles of the bill, which became the new act, were vetoed by the presidency. More importantly, those concerning the creation of the Data Protection Authority. The veto to the DPA was followed by an intense debate about its desirable nature and shape. In the last days of his mandate, and following its own statement that the DPA would be created still in his mandate, President Michel Temer issued the executive decree, we call it Medida Provisória 869, creating the Autoridade Nacional de Proteção de Dados, our DPA, with, however, no formal independence from the government and linked to the presidency of Republic. However, Congress must still deliberate about its creation and about several changes the same executive decree made in the LGPD, our data protection law. Regarding the issue that we are handling here today, it is interesting to ask, does the Brazilian law system recognize some kind of data ownership or a quasi-data ownership right? If we consider a quasi-data ownership right as the idea of a right to control personal data, as I already mentioned, I would say that it is a quite recent concept for our legal system when compared with European patterns. However, it is becoming an increasing tendency also in Brazilian law nowadays. The new Data Protection Act, inspired by Convention 108 and the GDPR, as well as by Brazilian law culture, entails the principle of information self-determination, as well as the right of data portability. Although the idea of data control and thus of a quasi-ownership right is growing more and more in the Brazilian law practice, especially under our Credit Reporting Act, the Brazilian Internet Rights Framework, and, of course, under the recent approved General Data Protection Act, I understand that a pure data ownership right would be very difficult to be recognized in our legal system due to the strong personality rights context in which data protection debate is embedded in Brazil. This approach assumes that personality rights are the concretization of the human dignity principle, and so they are understood as absolute, extra-patrimonial, non-transferable, and non-prescriptible. It is easy to see that this concept is hardly compatible with a pure ownership approach. Against this comparative background, I will now draw some conclusions. Growing economic importance of personal data has given rise to increased discussion about the ownership of personal data. On the one hand, some representatives of the industry claim property rights in data can support the investment made in the collection of data as well as its creation. On the other hand, a property rights basis for individual control over personal information is seen by some as a way to enhance the protection against unauthorized collection and use of personal information. There are already some initiatives trying to attribute some ownership rights to personal data. That is the case of the European proposal for a directive on the supply of digital content, in which user-provided data are considered a potential counter-performance other than money for receiving the provision of services and contents. Another example is the open data movement, which intends making government data available for reuse under open licenses through the idea that these data licenses are claims to government ownership rights in the data. If data protection is about and shall continue to be a form of control and reduce negative impacts of information processing on the rights of individuals, such as surveillance, discrimination, privacy violations in general, and considering that information can only be defined on a context as in Nissenbaum's concept, any solution which implies a simple ownership approach will not be able to deal with these impacts. In this sense, any idea regarding ownership should be considered carefully and only as punctual and complementary instrument in a complex data protection system, and not as a form as replace current guarantees designed to deal with the impact of information processing. Thank you very much.
Thank you. That was much appreciated by everyone and very clear statement. Also, thank you for making that distinction between the data as such and effort put into the collection and the processing. That was very helpful. I now move on to our last speaker, Mr. Yann Padova, who is a partner, currently partner at Baker and McKenzie in Paris, where he heads the data protection practice, and who was previously Secretary General at CNIL, the French Data Protection Authority. Mr. Padova is internationally recognized as a data protection law expert. He has been named in 2017 as the country leader for France by the IAPP, the International Association of Privacy Professionals. And it has been mentioned a few times before, he has recently written a very informative and insightful piece in French, in Revue L'Ami Droit de l'Immatériel. We're trying to push him to translate it into English. In that piece, he's going to the roots of the concept of property, going back to Roman law and the characteristics of property law there, comparing it with, or also looking at intellectual property notions, looking at the various dimensions. Is it something that belongs to the data subject and or the companies? So we are looking forward to hear your thoughts on this topic. The floor is yours.
Thank you, Peggy. Thanks for inviting me. It's my time for the disclaimer. I am a lawyer and a former regulator. So sorry, nobody's perfect. And I do my best on this one. I'd like to add on a few things that you say, Peggy, but why this debate is currently really on the agenda. I'd like to just supplement what you say, because I think one of the reasons why is that people have the sense that they're losing the control. They're losing the control of their data. They're overwhelmed by data collection, by the one we produce ourselves with our devices. And some think that through the ownership or property rights of data, they could regain control. So this is one of the drivers of why now we're discussing that. This discussion has been ongoing for at least 30 years on the other side of the Atlantic, less in Europe, for the reason Juan Manuel explained. But I think this is one of the drivers. May or might the property right provide the tool for people to regain control over their data and their data processing? That's one thing. The other thing is, well, people also want to have their share of wealth. They see that in our digital world, very big companies are very wealthy, and they've got this wealth through data processing. So they say, why should I benefit from this part of this source of revenue? Because this wealth flows from the data processing of my personal data. So this is also another ground for this ownership claim. They say that maybe I could be paid for my data being processed, and I have my share of the wealth. And these two things, I think they kind of, my belief is that they overestimate the value of the raw data, and they kind of underestimate the value of what makes the value of the data, I mean the processing and the recipe, the way it is analyzed by companies, because this is where the value lies. It's not because of the raw data, it's because of what is done with the data. And in France currently, we have really a strong debate over the last year, because a think tank produced a white paper about a year ago, a liberal one, saying Génération Libre, would say that personal data are mine, I own the data. And the parliament was inclined to go that, but the amendment didn't went along. So just to tell you that this is really something that is really on the agenda in France at least. And I see several issues in that. The first one is we've got already several case law in France that already say that who the data belongs to. And it's to the company. There are several criminal case law under the French Supreme Court say that, for instance, a company was the object of a robbery of data because someone stole the data from the company and sold it to someone else, personal data, I mean. And the company was officially recognized as being the victim of a robbery. And if you're a victim of a robbery, this means that something that belongs to you has been stolen. So if it belongs to you, can it belong to someone else? This is an issue. If we introduce property rights on personal data for data subject, then suddenly another owner will appear, and we are not sure how it's going to articulate with the previous owner that is already well known. And there's another case law very interesting about the criminal misuse of data, I mean, using data for other purposes, and that was a criminal offense too. And the victim of this misuse, criminal misuse, was the company too. So we've got already a sound and a good track record in France at least, and I think it's the same in other countries, stating that the official owner of the data is the company. And not to mention here the Directive 96 on databases, because as you know, if you have created a database with substantial investment in terms of human or financial resources, then the database belongs to the investor, I mean to the company. So we've got several sources already well established that already shown I have identified the ownership of the data. And under privacy law, we know that the entity that determines the purposes and the means, which is a critical notion, which is a data controller, is hardly the individual, never the individual. When you use a search engine or a geolocation app, you're not determining the purposes of the means, which is usually the case of someone who owns something. So even in data protection, it doesn't match with the traditional property rights. And the data subject has not its word to say. It's a user, but it's not the owner of the data. And suppose the data subject was to be considered as the owner, then what would become like, you know, when there is a collection without your knowledge at your expense, which is today considered as unfair collection of data, which is a criminal offense under French law, and it's a violation of the GDPR and all the privacy rules. But should you be the owner of the data, then this use of the data without your knowledge would be robbery. It wouldn't be unfair collection, and shows that the consequences of ownership are really structural, and we are not ready to face them. Second thing I'd like to share with you as a context, as a global remark, is that I see really emerging two trends that are not designed to articulate very well, and you've mentioned that, Peggy, on your introduction, is on one hand, we've got really people advocating for ownership for data subject or for companies, and on the other hand, we've got really some different instances that are really pushing for mandatory data sharing. So how can you introduce ownership right, which is by definition entails the right to exclude, because this is one of the substantial quality of a property right is the right to exclude someone to use this thing. I've got my car, I can exclude you from using it. I've got my land, I will exclude you from passing through it, and I will be able to make fences. So how can we see tendency towards pushing for ownership on one hand, and on the other hand, other movements, legal requests, or even tendency on white papers saying that we must have mandatory data sharing because that's good for innovation. How could you articulate these two tendencies? I don't know, personally. But I see that these two tendencies are not well designed to articulate and to cope well together. Now, that being said, I think that I'd like to elaborate a bit more on why I do personally think that ownership of the personal data would be even detrimental to the data subject, and I will try to elaborate, and for two reasons, economical ones and legal ones. It's not just a bad idea in my eyes, it could be really, could weaken the level of data protection we benefit, at least in Europe. For economical reason is that whenever you create a property right or ownership right, usually it's to create a market and transaction. All in history, and we go back to the 16th or 17th century, the founding father of property rights were thinking about the land. In order to make the land being well kept, with better investments, and with more wealth for the society, they created the right for property in order for people to take care of what they own, and they'll be able to exchange it and have increased the value, etc. So whenever you create ownership right, whether it is a sui generis or a traditional one, you create a market. And when you create a market, it is to facilitate transactions. So the very first question that comes after that is the price. What is the price of personal data? What is the price of your genetic profile, of your log connections, of your social security number? Who knows? And this means that it will take you a lot of time, personally, if you have the ownership of that, to find the proper right and the proper price for this data. This means that the transaction cost will be very high if you introduce that. And this means that the risk that flows from that is that you have more likely hood of having unfair deals because of the asymmetry of information between you as the owner of the data and the company that is willing to buy it, because you don't really know the value as the company. It is, you know, its specialty, it is its purpose, it's its activity to buy and sell data, so it will know the price. So it's traditional in the economic theory that when you have an asymmetry of information, you have more likelihood of bad deals. This means that if you want to prevent that, and all the thoughts from the US really insist on that, you have to create intermediaries, people that will negotiate on your behalf the proper rights, the proper price, sorry. Price and rights, interesting, the proper price. And this will increase the cost, because you have to give these intermediaries, these intermediaries, whatever you call them, some money to do that. So it's not sure that you will gain a lot by introducing proper rights for that. And if we go along this price issue, this means that if you have ownership, you can sell whatever you want. So this means that some forbidden use of personal data today would be permissible. It only will be a question of price. Today, as you know, under the GDPR, it's forbidden, the general principle is forbidden to process health data, genetic data, racial data, etc. But then, if you've got ownership, then it's just a question of price. So you would have unpermissible use that would become permissible use, but what will adjust is the level of price. How much can I get from this? And this creates serious issues in terms of, the equality between, for people, the equality of level of protection, because then what will happen? If you've got a very high price for sensitive data, people that are wealthy enough with high level of revenue won't sell it, as opposed to people with lower revenue, with lower income, will be more tempted to sell it. So this could lead to an equal level of data protection because of this introduction of the price mechanism. And the very same conclusion flows from, if you think about getting money from your data processing, you're being paid by someone or a company because the company process your data. If you're wealthy, you won't be interested, so you won't buy it and you won't go there, meaning that you won't give your data for an amount of money because it won't be interesting for you. As opposed to people with lower level of income that will be more tempted to go on that. So this is the same result. I mean, you could have an equal level of protection depending on the level of income because of this introduction of property and price mechanism of data protection. And I think this is a very strong argument, economical argument against ownership. The second economical one is that whenever you create a market and you enable more transaction, the more you enable transaction, the more you enable accumulation. So this means that property rights could lead to more data gathering and more accumulation of data. And there's a professor in the US, Judy Cohen, said that at the end, property rights and markets rights for data protection, for personal data, could lead to more transaction and less protection. And I do agree on that. Because what is rare today is not the data, it's the level of protection. And the level of protection for some economists is comparable to what we call the public good. A public good is like the quality of air. The defense is something you can have without depriving someone to have it. That's a public good. And the level of data protection may be and should be considered as a public good. This means that if you create ownership and privacy rights on this one, you will decrease the level of protection because you will transform into a private good what is today a public good. And that would be also detrimental to the people at the end. The second kind of reason I see why data ownership might be detrimental to people is legal one. And we've touched upon that before. Is the question of further use, further processing of the personal data. Suppose I've sold to you my car, which I'm not ready to do, but suppose I do that. You can paint it in pink, you can crash it, you can cut it in pieces, you can do whatever you want. I have not my word to say. And if you introduce property rights on data, personal data, that's about the same thing that should happen, unless you create a very specific rights with limitation of further use. But if you have a traditional property right, which some do advocate for that, you will totally lose control of a further use of this personal data, which is a critical issue, because then you can have hostile further use, and you say that, or unexpected further use of this personal data because you've lost control. When you've sold something, you have no control ever on what you've sold. And this is where I think we really see the core issue there, that even if you introduce property rights, you will not gain control, maybe at the beginning, but not on time. And if you project yourself in a medium or long term, it's quite the contrary that may very well happen. And this is where personality rights provide more protection, in my view, thanks to, you know, the purpose specification principle. Whenever you collect personal data under EU law, you must process for specific and explicit purposes, and you cannot process for incompatible further processing. And I think it's a very core and key protection which will be dismantled, where should the property right to be introduced. And other rights that are core to our value to personality rights today would be very much challenged by the property rights, such as rectification and access right. How can you rectify something that does no longer belong to you? What can you do? How can you access to personal data that are, to some extent, no longer personal because you sold it? You see that all the key principles, key protection that we have under this personality rights principle that are now enshrined in the GDPR, but has been in the Convention 108 and for many years, would be slowly but surely totally dismantled or challenged, at least, by the introduction of property right. So to conclude on that very briefly in order to keep time, I say that ownership does not lead to more control, quite the contrary in my view, and I hope I've demonstrated that very briefly, but it's true that in my article is much more elaborate on that. And more control does not mean ownership, but rather the enforcement of personality rights and the GDPR here in Europe. Thank you.
Thank you very much, Yann. So I get from the panelists that there is not much enthusiasm for a data ownership right, just like the idea of ownership on non-personal data has been taken out of the regulation. So we have a few minutes left. I apologize that there's so little time left, but we had such interesting interventions from the panelists that I didn't want to interrupt them. Please, if you want to raise a comment, if you have a question, could you move over to the microphone and briefly introduce yourself, please?
Good morning, Matthew Newman. I'm a reporter at MLEX here in Brussels. Question for Yann Padova. Just in light of what you were just talking about in terms of paying for data, you may have seen the stories yesterday about Facebook and Apple. So there's lawsuits and lots of criticisms that paying teenagers, 13-year-olds, $20 a month for access to their iPhone, all the data in their iPhone, $20 a month, is going too far in terms of pricing data, and particularly for data protection issues about children, 13-year-olds. So how should data protection authorities look at that? Is there a right price for data? Is there a wrong price for charging teenagers?
Well, that's a difficult question. As you know, I'm no longer in charge of the CNIL, so I can't speak for the regulators. But that's really an illustration of what I've just described, is the fact that to monetize data might very well not lead to better data protection. And this issue will be assessed by regulators in terms of transparency and consent. First, the level of the age, 13 or what, and then was the consent informed, if it was legally obtained, and how was, to what extent it was a fair processing. So, and then I can't answer your question in terms of the level of price, because I don't know. That's, you know, that's a decision for the company. It's like $13, you say, for 20. Well, it's not impossible to go that way, but it has to be, you know, very well legally designed at the origin. And I don't know the case specifically, so time will tell.
You want to react?
Only one word, but you can revoke the consent. you can revoke the consent. This is not really a price in that sense, because in terms of private or personality right, you can revoke the consent. You are not subject to that consent only for the exercise of your personality rights. So this is not a problem.
So can I ask a question as a business person? Do you have to give the $20 back if you revoke consent?
Yeah,
Right.
that's a good one.
This is the point. We cannot mix up personality rights with data ownership, with property rights. Personality rights continue to exist. And
So the answer is no. You keep
the answer is
20.
no.
Well, that's why I'm not in favor of ownership, because I think the contradiction can't be overcome and could weaken the level of protection at the end. So I think it's a bad idea.
I have to say the debate reminds me slightly to the debate we had with the first programs on TV where people were exposed, like the Big Brother or Temptation Island. And these people participate voluntarily to these programs, but you also have debate on shouldn't they be protected against themselves, because they are remunerated in the sense that they also get, because they become famous, they get money out of it. But so I see some resemblance there, and I guess the resemblance is human dignity and personality rights. There was another question, please.
Hello, Natalia Belova. I'm a computer scientist at INRIA in France. So I have a question from our researchers' perspective, and it's about public repositories of personal data. So I have two case studies. One is, so we have big repositories of software, and there are developers who are writing the software, and there are actually a trend now in the software engineering community of mining the software repositories and extracting data out of these identifiers of the developers, but also the style they're using to write their code. So something that's actually pretty personal, and it's public at the same time. So what are your opinions on this first case study? Is it fine? Is it what the researchers should do to be compliant with the privacy laws? How they are supposed to do their research? And the second question, the second case study is very similar. It's about public repositories of faces, so for face analysis and face recognition. There was an side event yesterday about this. I have a colleague who is asking me this question. We used to have these millions repositories of millions of faces, and they are doing their analysis. Are they okay to continue doing what they were doing, or they are supposed to change their procedures? So what is your opinion?
Okay, who would like to take that question?
Well, briefly, it's a traditional compliance issue. I mean, it's personal data. How did you collect it? For instance, take the facial, the biometric information you have. How did you collect? On what ground? Were people informed? Are they able to exercise their rights? You take the checklist and you see if you're compliant. If you took that without their knowledge, not informing, keeping it forever with unspecified purposes, well, I'm not your lawyer, but would be careful.
So in case of faces, normally you don't even know where this data came from, and you cannot even know who is the person on that image. You don't even have the name of that person. You don't know how to contact that person, even if you wanted to.
I can't. I'm skeptical of considering an image of someone as a non-personal data today.
I'm afraid we need to close here. Voilà, yeah, as confirmed. I would like to ask the one who, you still have a comment. Can you please come here and discuss it bilaterally? Because we need to free the room for the next session, I'm afraid. Thank you all for being with us. Thanks to the panelists and thanks to the organizer. Hope you enjoyed it.